So it's a good question. The question is whether the judge not ordering another evaluation is a positive step. We opposed another evaluation being conducted because we did not want another undue, unnecessary delay, as we discussed in court.
How many evaluations have been done in this case total?
I would have to check for the exact number, but the number of evaluations, there were several conducted before he was admitted to the state hospital and then several since.
And after, so I know you guys set the prelim for November 14th. You have up until October 3rd to do the restoration hearing. So after the prelim or after the restoration hearing, he could be released from the state hospital and could be sent back to the jail and get off his meds. Is that why we set the prelim? Can you kind of explain that concern about when a defendant might be going back to incompetent after being found competent?
So good question. What I'll share with you is when a defendant is determined to be incompetent, he must remain at the state hospital to receive care, treatment, and be evaluated for restoration of competency. So the court today ruled from the bench that the defendant has to stay at the state hospital to be treated there. If he's restored to competency, under the law, he could be transported back to the Boulder County Jail, or he could remain at the state hospital.
Is it up to the judge to make that determination of competency, Mr. Dougherty?
Ultimately, it's up to a judge to determine whether a defendant is competent or not.
And what is the next step in the process? What happens now?
So, as you may have heard in court, the court is going to be waiting for the attorneys to submit a 3-day setting for a hearing to be conducted. It's called a restoration hearing, for the court to make a determination, a judicial finding of whether the defendant's competent to stand trial or not. And what I would share with your viewers, and I know you know this, but I would share with your viewers, is competency is with regards to whether the defendant has a rational understanding of the legal proceedings and is able to assist his attorney in his defense. So it's not about his mental health condition on the day of the incident, it's about his mental health condition today. So on August 18th, the state hospital provided a report to the court in which they concluded that he had been restored to competency and would be able to stand trial and the case would be able to move forward. The defense obviously requested another evaluation, and instead the court granted our request and set it for a hearing to determine if in fact the defendant has been restored to competency, and if so, we can move forward with the preliminary hearing and the trial in this matter.
And when will that hearing take place?
So the restoration hearing has to be sorted out based on the schedule for the doctors. So the court asked the attorneys for both sides to consult with our experts and with the doctors at the state hospital to determine what date, but it has to be before October 3rd. If the judge determines the defendant is competent, the judge then set it for a preliminary hearing to be held on, I believe the date was November 14th.
And one more question. And that preliminary hearing, then what happens?
So preliminary hearing is held on felony cases when someone's in custody to determine whether there's probable cause to move forward with the felonies that have been charged against that individual. That happens in many of the felony cases we have in this courthouse and throughout Colorado. And there are, a number of witnesses called. Generally, they're law enforcement witnesses to talk about the evidence in the case, and the court has to make a determination about whether probable cause has been demonstrated so that the case can move forward.